Hi, Mandy from Grow HR. In this video, I'm going to be talking about communicating and consulting with employees. Over the last week, we've had calls from employers who were looking to reduce pay to 80%, reduce people to subsidy amounts only, or require staff to take annual holidays. This isn't as simple as just requiring any of those things to happen. Employment law does apply, and we've seen that in case law in the last year, and it's what's called a duty of good faith. And what we mean by this is making sure that staff are communicated with about any proposed changes to their contractual obligations or entitlements, and that they've got an opportunity to come back with any other feedback, suggestions, ideas they might have. In some cases, variations to employment agreements will need to be agreed because there simply isn't other provisions available that the employer can rely on. So in terms of preparing to communicate, some things to be thinking about are: what are your financials telling you? What is your trading performance year to date? How did you go for the first half of August? What can you sustain and for how long? So understanding your financial position is really important. If you're claiming the wage subsidy, it might be about how much will that help and what will that further sustain. The next is, what is in the employment agreement? Do you have business interruption or force majeure provisions? What are you wanting staff to consider and get agreement on? Are you wanting to talk to them about whether they'd be agreeable to a reduction in pay, or you invoking the business interruption clauses, or for them to be perhaps taking some annual holidays? How are you going to tell your story? So how are you going to explain what is preventing you from meeting those contractual obligations, what it looks like, what your thinking is, what you're proposing, and how that might impact? So telling the story is really important for people to understand why you're having this conversation with them and what you're thinking. And finally, it's how much time can you give them to be able to process what you're telling them, and for them to be able to realistically come back to you with any other ideas or thoughts that they might have. So once you're prepared in terms of progressing from there, your process is to communicate with staff, tell that story, what you're proposing, and when you need for them to come back by with any other suggestions or ideas they have. It's then considering that feedback and making your decisions. If it is a situation of invoking a business interruption clause, then it will be about communicating that, when that applies from, how that applies. If you don't have those, it would be then around offering a variation to the employment agreement. For annual holidays, if you haven't got agreement on when annual holidays are to be taken, it is a minimum 14 days notice required in writing, and you can only require what is already entitlement to be taken. So if people are still working towards entitlement, then you can't require that to be taken no matter what. The real biggie is that there is a 6-year liability period for wage claims. So it's imperative that you get this process right now, because it's a long time to have as a liability or potential liability period if you potentially get this wrong. So if you are in a position that you're thinking about consulting or communicating with staff about potential changes to contractual obligations, then get in touch with a member of the Grow HR team, and we can certainly help you through that process and look at how that might work for you. Keep working with your business advisors and accountants as well around your financials. What is your performance? How are you tracking? And how long can you sustain a contractual position for? So hopefully that gives some food for thought. Get in touch if you need to further discuss. Take care. Thank you.